What are the remedies when infringement occurs? The legal consequence of infringement can lead to civil liability or criminal liability. Now, when we say civil liability, we are referring to private action remedies like injunction, damages, account for profit. Criminal liability refers to public action sanctions like arrest, detention, destruction, fines, imprisonment. Patent infringement is an outlier because patent infringement does not have any criminal liabilities, whereas trademark and copyright can attract criminal liabilities. With regard to civil remedies, when an infringement suit is filed before the court, a person can ask for an injunction. Injunction is a relief restraining the infringer from doing the infringing acts. Now, the injunction can be an interim injunction. Interim injunction is an injunction that will operate till the suit is finally disposed of. And permanent injunction. Permanent injunction is when a person succeeds in the suit, the right holder succeeds, then the infringer is permanently restrained from doing those acts. There could also be something called the ad interim injunction. Ad interim injunction is when a right holder files a case without giving notice to the infringer, and we had already mentioned there could be instances where it is not feasible or advisable to file a cease and desist notice, and in such cases the right holder will directly approach the court. When the right holder approaches the court, the right holder can ask for an ad interim injunction. Ad interim injunction is even before the interim injunction is granted. Normally the interim injunction is granted after hearing both the parties, because the defendant may have some defense. So the court will not be inclined to grant an injunction without hearing the defendant. But if the nature of infringement is such and the damage that infringement can cause can be irreparable, then the right holder can ask for an ad interim injunction. That is, an injunction to be granted even without hearing the other side, which is called ex parte injunction, even without hearing the other side, in such a way that this ad interim injunction will hold good till the court decides whether an interim injunction has to be granted, which will be once the defendant appears in the case and contests the order of injunction. So an ad interim injunction is something which is granted before an interim injunction is granted, and the interim injunction, if it is granted, will continue till the court proceedings end, and once the court proceeding ends, a permanent injunction, if the party succeeds, will be granted. Now, before granting an interim injunction, the court will have to weigh the merits of the case, because interim injunction is a tricky thing, because when it's granted restraining a defendant, it will hold good till the case is disposed of. In normal cases, trial of an infringement case can take a long time. It could be a few years. So the idea is that to stop the infringement, the interim injunction is allowed to continue till the trial happens. So the interim injunction could in effect be in force till the case is finally disposed of. The danger in granting an interim injunction is that eventually, if the defendant succeeds in the case, in other words, the plaintiff or the right holder is not able to prove infringement, or the acts which the infringer did do not amount to infringement, or the infringer's acts were non-infringing, they were beyond the scope of infringement. In such cases, if an interim order is granted, then it will in effect put the defendant out of business while the interim order continued. So the danger of granting an interim order is that the courts will eventually be saying something about the matter without knowing what will be the final outcome. So they could grant an interim injunction, and later on, after trial, they may even revoke the patent, or they may find that the defendant did not actually infringe. So during that time, there is a period during which the defendant was eventually, it would turn out that, was restrained without any legal basis. So to prevent this, courts would normally evolve a approach so that it weighs the pros and cons in such a way that it grants an injunction only after weighing the pros and cons, because the court cannot at this stage look into the merits of the case, because the merits of the case, which will bring the details of the case, would normally happen during the trial stage. So this is not the trial stage. At the interim stage, the court cannot cross-examine people. It cannot allow for expert evidence. There are certain limitations during the interim stage. And during the interim stage, the court would evolve this three-step. The court will determine whether there has been a prima facie case, whether there has been irreparable injury or hardship, and where the balance of convenience lies. So based on this, the court would grant or not grant an injunction. In other jurisdictions, if the court is not clear whether to grant an injunction or not, if the court is to grant an injunction, the court will insist on a cross undertaking from the plaintiff, because the plaintiff is the person who will enjoy the injunction, because the defendant's activities will be stopped. The court will ask the plaintiff to give a cross undertaking that in the event the defendant succeeds in trial, then the plaintiff will compensate for restraining the defendant. So the cross undertaking in damages is something which has been used by courts in different jurisdictions, but we have not seen that being employed in our country so far. Permanent injunction is what the court will grant after it looks into the merits of the case, and it is passed along with the decree after considering all the evidence in the case. There is also an injunction called the Mareva injunction, which is used to restrain a defendant from disposing of the assets, which may be used to satisfy the plaintiff's claim. Now, in a case which involves piracy, there is a possibility that if the defendant gets to know that there is a case filed against him, he can quickly dispose of the assets, or the assets could be in a third party's hand. In such cases, there can be a Mareva injunction. It comes from another case by the same name, where it is possible to restrain the disposal of the assets. So a restraint order which curbs the disposal of the assets can be granted. That's a type of injunction. And there could also be an ante and pillar order which permits the plaintiff to inspect the defendant's premises. It's like a search which is allowed by the court. So the plaintiff will have to get an order from the court requesting search of the defendant's premises, and there could also be a following order to seize the goods as well. With regard to damages, the damages are granted for compensating the loss suffered, and the courts normally grant actual damages, not remote damages that directly flow from the infringing act. And damages are granted for what the plaintiff has actually suffered due to infringement. Damages to goodwill and reputation on account of undermining the plaintiff's reputation and goodwill are also granted by the court. Damages could also be exemplary or punitive, like damages granted for punishing a person. Now, this is to deter the wrongdoer or others who may be inspired by the wrongdoers to involve in unlawful activities. Apart from damages, the court can also ask the defendant to keep accounts of profit. The plaintiff is entitled to require the defendant to account for the profit made by him, but an account of profit is an alternative to damages. It can't be claimed along with damages. Criminal remedies, as we mentioned, are available for copyright and trademark. An offense of infringement of copyright or any other right would be treated as a criminal wrong. The offense is described, it should be an offense under section 63, and the imprisonment could be from 6 months to up to 3 years, and they could also be a fine of 50,000 to up to 2 lakhs. The police has the power to seize infringing copies. This is a power that is given to the police, and they can seize without warrant all copies of the infringing work. They don't require a warrant to seize the goods. Now, if the infringer or a person who aids the infringement is in possession of plates for making infringing copies, then there could be an imprisonment extending up to 2 years and fine. And the court can require delivery of all infringing copies to the copyright owner. And in case of offenses by companies, every person who was responsible for the company's affairs at the time of the offense shall be held liable. Criminal remedies also exist for trademarks. If there is a false trademark or falsifying trademark, then that can attract criminal remedies. The penalty for applying or selling goods with false trademarks is also a criminal offense. There is imprisonment of 6 months, which can extend up to 3 years, and fine of 50,000 to rupees 2 lakhs. And there could be an enhanced penalty for subsequent conviction, the imprisonment of minimum of 1 year and a fine of a minimum of 1 lakh. Criminal offences can be registered for registered as well as unregistered trademarks, and forfeiture of goods is another relief. There can be a direction to the government to forfeit all goods relating to which an offence is committed, and the police again has the power of search and seizure. Patents don't have criminal remedies. That is because of the nature of the infringement analysis. We had already mentioned, unlike copyright and trademark, where a mere comparison of two goods can determine infringement, patents require certain special knowledge and looking at documents, and it is a job of the court. Only the courts can determine infringement. For that reason, patent law does not make infringement into a criminal offense which the police can take cognizance of. Seizure cannot be done by the police officer on face of alleged infringement. It can only be done by taking an order from the court. There are some border measures by which entry of imported infringing goods can be stopped. This can be done by the administrative authorities. It is done by the custom officials. Now, earlier, this was also used for patented goods, apart from trademark and copyright. Earlier, this was used for patented goods apart from goods covered by trademarks and copyright, but recently the power to seize patented goods has been cut down due to certain litigation in the high courts.